Hello, I'm Charles Goldstein, your advocate at work. Today I'm going to talk to you a little bit about termination. Termination of employment, which we oftentimes refer to as being fired, is a very unfortunate circumstance that can be attributable to many possible causes. But there are statutory and case law protections for you if you have been terminated from your job. We have what's called constructive termination, which means that your job conditions became so unbearable that any reasonable person would have quit their employment. And in fact, you may still be able to collect unemployment if you're able to meet that criteria. It's very important to know that you can request your personnel file following your termination, and the employer must provide you a copy in a short order. Also, you may request the reason for termination, and the employer is likewise required to produce that for you in writing. Now, when it comes to job references, the employer is not required to provide any certain job reference for you. There's no law. Some people think that they must provide any information other than dates of employment. Otherwise, employers would be at risk of being accused of some sort of defamation, and that's what they often try to avoid doing. If you're owed pay at the end of your employment, the employer must provide that pay to you, and after you make your demand for any last pay, they have 24 hours to provide that, or there is a substantial penalty. We have many cases in our office of what is called wage theft. That means the employer is not paying the appropriate amount at the end of the employment for what is owed to the employee, including for paid time off, and penalties accrue another average day pay for every day, up to 15 days for days that you remain unpaid. If you have questions about being terminated or any other questions about employment law, feel free to contact us. I'm Charles Goldstein, your advocate at work.